Okay, we've got question 1 here from 2004 February. It's a straight criminal procedure essay and a little touch of evidence in kind of a way because it deals with statements. So let's take a look at the call to question first to see what's going on here. It says, how should the court rule on Dave's motions regarding the following items, and on what theory or theories should it rest? Well, when they talk about the defendant's motions, so D is Dave, the defendant, and this is a criminal case, and he filed motions. I like to look up the paragraph right before the call to the question because technically that is actually still part of the call to the question because the fact pattern's over and it actually shows what's going on, what motions the defendant's making. Don't forget, the defendant's making a motion to suppress evidence based on a constitutional violation. So, Dave was charged with robbery. I'm going to the paragraph above it because this is part of the call to the question. He's chosen not to testify at trial. He has, however, moved to, that's his motion. He's filing a motion to be allowed to read aloud a newspaper article to be selected by the judge without being sworn as a witness or subject to cross-examination. So you see, number 1, reading aloud the newspaper article. Reading the article. Okay? And when you're on the exam, if you just want to put that as the call of the question, that's fine. You do not need to type out the entire call of the question. The reason why I'd actually like you to do that, not exactly type it out verbatim word for word, but so you know specifically what you're being asked and that you don't miss it. Again, if you have not read this fact pattern yet, pause it right now, read the fact pattern 2, 3, 4, 5 times, slowly and carefully, pick up on the detail. As you notice, the more times you read a fact pattern, the more you'll see. It's really odd. I've done certain essays 6, 7, 8 times, and I look at it and I'm like, whoa, what? Never saw that. In fact, one of the things I noticed, I must have done this essay probably about a dozen times, and one of the things I've seen for the first time right now is on what theory or theories should it rest. I've never noticed that before. I would have never imagined that was in a criminal procedure essay. I actually just kind of surprised myself with that. And I've done this essay quite a bit. So, reading the article. He also moved to exclude from evidence the money found in the briefcase. So that's number 2, the currency. And we know it's in the briefcase. Again, you'll see when it says he moved to, that's the motion to suppress. That goes to number 2. He also moved to exclude evidence from the money found in the briefcase. His statement to the officer. And number 3 is Dave's statement to the officer. And that's where the evidence, they don't really classify this as a crossover at all. In fact, most people would think it's just straight criminal procedure. But it's got one little tiny thing about evidence, and that is what is in a statement. In evidence, a statement is an oral or written assertion if it's intended to be an assertion, or nonverbal conduct intended as an assertion. What the hell did I just say? Exactly. Oral, I make a statement. I say something. I'm going to the park. That's a statement. If I write down, I'm going to the park, like I send you a note, that's a statement. It's a written statement. That's what documentary evidence is. You know, the best evidence rule, business records, those are all in writing. Those are all statements. It's written. It's a written statement, written hearsay. So there's oral, there's written, and there's nonverbal conduct. That means silence. Can you make a statement by remaining silent? Absolutely. If you ask me, did I go to the park last night? I shake my head yes without saying anything. That's nonverbal conduct indicating a response. I'm intending to say yes. If I asked you which person was it and you point to number 3 and you don't say anything, by pointing, that's nonverbal conduct and you're intending it to mean the person I'm referring to is number 3 because I'm pointing at number 3 as probably the culprit or the person in the lineup who committed the crime. So think about it. A statement can be oral, that means anything you say, written, or nonverbal. As long as you intend it to be an assertion, nodding, saying yes, pointing to somebody to identify them. So a little bit of evidence we're going to review. And number 4, it says he wants to move to exclude the shotgun, and we got the shotgun. Okay, got it. A bank was robbed at 1 p.m. When the examiners give you times, dates, numbers, anything in quotes, Pay attention to punctuation, exclamation points, commas, periods. It is so important. So when you're reading these, you have to slow down and really read this carefully and slowly. When you're on the bar exam, for anyone who's ever taken a bar exam or even in a law school class and they say go, you'll have somebody guaranteed start banging on the keyboard in the first 30 seconds. And crazily, a lot of people's reaction is, oh my God, they're so smart. I'm behind. That person knows what they're doing. That person has no clue what they're doing. How could you possibly know what to write until you've had a chance to read it and process it and analyze it? So if you see someone banging on their keyboard within the first 30 seconds, thank your lucky stars. I mean, be blessed, because that person's going to not pass. There's no possible way a human being can look at this fact pattern, see it for the first time, comprehend it, and just start typing within 30 seconds. It's humanly impossible. I don't care if you've even seen this before, you still can't do it. Okay, so 1 p.m., notice what time it is. By a man who brandished a shotgun and spoke with a distinctive accent. Got it. The teller gave the robber packets of marked currency, which the robber put into a briefcase. So we know where the money is. We talked about the currency in the briefcase. That was in the call to question. I remember that. All right, and I know about he's got an accent, so something about reading the article aloud. Accent, all right. At 3:30, so 2.5 hours later, the police received a telephone call from an anonymous caller. Now, anonymous callers are generally not reliable. You don't know who the person is. They could be setting the defendant up, somebody they don't like. You get in a fight with a significant other, and let's say your girlfriend was to call the police and tell them that you've got drugs in a briefcase just to mess with you. The officers aren't allowed to search you based on that anonymous tip. They need more. They need some kind of cooperation. They need some kind of veracity. That needs to be reliable. So here we have an anonymous caller who described a man standing in a particular corner in the business district and said the man was carrying a sawed-off shotgun in the briefcase. Okay. Question, how does this caller know that? We have no information of how the caller knows that. Because it's anonymous, we can't verify who it is. A man standing in a particular corner in a business district with a briefcase. Is it odd to see a man in the middle of the afternoon carrying a briefcase in the business district? Is there anything suspicious about that? Absolutely not. So this tip is not reliable. It's not being corroborated. It's not credible. There's no reason to consider this probable cause or even reasonable suspicion for that matter. In fact, Supreme Court case from 2000, almost very similar facts, said that the police did not have reasonable suspicion to even stop the person and conduct a Terry frisk based on these facts. Within minutes, a police officer who had been informed about the robbery and the telephone call observed Dave holding a briefcase at that location. Okay, if I tell you there's a guy downtown, if I tell the police, hey, there's a guy in the downtown business district holding a briefcase in the middle of the afternoon, probably on a business day because the bank's open, there's absolutely nothing suspicious about that whatsoever. So he observed Dave holding the briefcase, and Dave fit the description given by the anonymous caller. Just because you fit the description, I mean, again, we don't know how they know the information that they know. They did not explain anything, and it's anonymous, so there's no way to verify it. So what should the officers do in that situation when you have an anonymous tip? Well, what they can do is just investigate. They'll probably do some recon. They'll follow the defendant from a distance to see if he does anything suspicious, to check his behavior, his moves, where he's going, who he's consorting with. But they can't stop him right now. They can't even seize him right now. They definitely cannot search him. The officer approached Dave with a service revolver drawn but pointed it at the ground. That is excessive. That is completely unconstitutional. All right, so what we have here is once the officer drew his service revolver, there has been, I'm assuming we're going to start in the beginning. Actually, probably here, because reading the article, that's going to be in court. Briefcase. So by the officer pointing the weapon at him, he's not going to feel free to run away and leave, especially now that a violent crime in the officer's mind is being committed, which is a felony. So here we have, it's definitely a seizure. Okay? And a seizure can be by the officer grabbing you, holding you, or using a show of authority to get you to stop, and then you actually stop. So here, the officer is pointing a service revolver. That's enough to make a reasonable person not feel free to terminate the encounter. He explained the reason for his approach, handcuffed Dave, handcuffed. Now he's not free to leave, and opened the briefcase. All right, so with this, he's been seized by the show of authority. And the officer now searched the briefcase. He opened the briefcase. The briefcase contained only the marked currency taken in the bank robbery. All right, that's it for call number 2. Let's stop there. So we initially have a seizure because he's been stopped. Now he's been arrested and his briefcase has been searched. Question is that sufficient to be a search incident to a lawful arrest? Seizure is based on reasonable suspicion. This is based on probable cause. Oftentimes in criminal procedure essays, and please understand this because it happens over and over and over again, you're almost guaranteed on a criminal procedure essay to have to discuss reasonable suspicion and probable cause. Why? The answer is it contains an analysis of the facts and they want to see how you're going to discuss them in a lawyer-like manner. So reasonable suspicion and probable cause, I didn't actually verify it, but it shows up in almost every single criminal procedure essay, especially ones dealing with the Fourth Amendment. You're going to be discussing reasonable suspicion and probable cause. Here, probably both. So definitely no probable cause to search. Is there sufficiently strong facts to believe that the defendant, that this guy, Dave, committed the crime? No, all we have is an anonymous tip to go on that has no indication of reliability. So it's clearly can't search his briefcase, so it wouldn't be a search incident or lawful arrest. There's absolutely no probable cause. All right, well, is there a reasonable suspicion? Could the officer have conducted a Terry stop and frisk and investigated? Believe it or not, based on these facts, there isn't even enough for reasonable suspicion, let alone probable cause. So reasonable suspicion as articulable facts that criminal activity is afoot. This guy's not doing anything suspicious. We just have a phone call from an anonymous person saying that he's going to have a briefcase in a business district in the middle of the afternoon. Nothing suspicious about that. So it's unlikely to be a Terry stop, or a valid Terry stop, where they could just pat down for weapons. And even if the officer was able to pat down for weapons based on the belief that the defendant was armed and dangerous, a bank was just robbed, he wouldn't be able to search the briefcase under Terry. And because there's no probable cause, wouldn't be able to search it incident to a lawful arrest there. Don't forget, there's also some other facts here that would show no probable cause or reasonable suspicion, and you can kind of use the facts in either one. The bank was robbed 2.5 hours ago. Do you really think the person who just robbed the bank is hanging out in the same area where he can be noticed with the contraband, the evidence of the crime? It's highly unlikely. So that should also factor in the analysis. It's 2.5 hours later. And it's around the same place where the robbery occurred. By the way, this turns out to be the most important call, the heaviest call. Very light, second most important call. And generally the examiners do that. They won't backload it. You'll almost never see. I can't imagine one time it may have been done. When you have 4 calls to the question, you better believe the most important calls, the ones with the most amount of, the most issues, the most points, if you will, are in the beginning. And here it's no exception, it's in number 2. So again, no probable cause, no reasonable suspicion, and of course, by searching in the backpack, or there is no plain view, because it wasn't immediately apparent. Now that's the issue you may or may not see. The examiners actually were looking for it. The item was not in plain view because it was inside the briefcase. It wasn't like it was bulging out of his pockets or in his coat. I don't know how big a sawed-off shotgun is. I don't even know how big a real shotgun is, but I believe they're actually pretty big. I think one of the answers discussed the difference between a shotgun and a sawed-off shotgun and how they're marketably different. I don't know guns, but it's definitely something I'm going to look up. I should have looked it up before I did this. Nevertheless, it wasn't in plain view. So they should definitely grant Don's motion to suppress the currency in the briefcase. Okay. The officer said to Dave, I know you're the one who robbed the bank. Where's the shotgun? All right, so D's statement, here we go. Goes to number 3. Because he's handcuffed, he's in custody. And the statement, where's the shotgun, is likely to elicit an incriminating response. So Miranda deals with statements, and this is the Fifth Amendment. This is the Fourth Amendment. This is actually technically the Sixth Amendment, if you will, probably a little bit of the Fifth as well. This has to do with the Fourth. A little bit all over the place. They don't generally do that. So he's handcuffed, he's in custody, he's not free to leave, likely to elicit an incriminating response because an answer to the question will reveal evidence of the crime. In response to that question, Dave then pointed to a nearby trash container in which he had concealed his shotgun. So, he made a statement. And the statement, because it was nonverbal conduct, it's essentially the same thing as saying, hey, the shotgun's in the trash can. But because it's in violation of Miranda, the statement will be excluded. So exclude defendant's statement where he points at the container. However, there's actually 2 parts of this statement. And it was really kind of hard to catch. He pointed to a nearby trash can. That's the nonverbal conduct. That's the statement. And then he said, I knew all along that I'd been caught. Well, the officer never asked him that question. Once he pointed to the trash can, that's it, it's over. The officer asked the question, he pointed to it, he answered the question. Now he just blurted something else out after that. So the second issue underneath this was, the first one was Miranda, in custody, likely to elicit an incriminating response. The nonverbal conduct is the equivalent of a statement, and because it was during a police interrogation, he should have been read Miranda rights. The last thing is spontaneous. He actually just blurted out, I knew all along I'd be caught. That statement can be used against him because it wasn't in response to police questioning, therefore it doesn't violate Miranda, and you would separate the statements, and I think the better analysis would definitely do that. And of course, now we have the shotgun. So the question is the shotgun going to be fruit of the poisonous tree because it stems from, they only found the shotgun based upon the unconstitutional search and seizure, and also it's the shotgun is part of the violation of the Miranda because the officer wouldn't have found the shotgun, or at least we don't know, probably wouldn't have found the shotgun right now if it wasn't in response to the unconstitutional Miranda. But don't forget, Miranda only applies to statements. So a violation of Miranda will lead to the exclusion of the statement. However, Miranda does not exclude physical evidence. So the actual gun itself is admissible, at least under the Fifth Amendment. And now the Fourth Amendment's a different issue. So the gun is admissible under the Fifth Amendment because a violation of Miranda does not require suppression of physical evidence. And the reason is, the confession might be fake. The gun is real. We know that. So there's no chance of coercion, there's no chance of deception. We know we're not lying because we actually have the physical evidence, whereas you might confess to something that you didn't do. That's why Miranda only excludes statements. The last thing is, because the gun is in a place where the public could access it, I mean, it is in a trash can. A lot of little kids play in trash cans, a lot of bums go in trash cans, and therefore we have the public safety exception to the Fourth Amendment. And that has to do with the gun posed a danger to the public. Somebody could have picked it up and used it. A kid could get a hold of it. And therefore, it's kind of like an emergency situation where the officers can circumvent the warrant requirement on the Fourth Amendment under the public safety exception. And they can also get around Miranda that way. Besides, Miranda doesn't apply to physical evidence. Okay? Well, I think that, the last thing is reading the article out loud. Now, this is kind of interesting. If you didn't know how to answer call number 1, you're not alone, because I actually searched and searched and searched. I found absolutely no case law on it. I think that they're getting at this. Well, Sixth Amendment has the right to a fair trial, and unfortunately, this has to do with the prosecution's the one who's not going to be able to have the fair trial. The Sixth Amendment doesn't apply to the prosecution, only applies to the defendant. So he wants to read the article, and he's essentially giving testimony, but he does not want to be cross-examined, and he doesn't want to be sworn as a witness. So he's not taking under oath, which kind of dampers the credibility and the reliability of the statement. And by not being subject to cross-examination, he could easily fake it because the prosecution is not going to be able to determine his credibility to see if he really does have, what kind of accent he has, whether he does or he doesn't, whether or not it's legitimate. And the jury's not going to be able to hear it. I'm going to have a hard time allowing the defendant to read the article in open court without being sworn as a witness and without being subject to cross-examination. It just isn't fair. It's fundamentally unfair. It's a testimonial statement, and granted that he's got a Fifth Amendment privilege against self-incrimination, and that's essentially what they're getting at. But it doesn't allow that, in my opinion, I think the better view is, it's not going to allow the defendant to essentially testify to something, because he's obviously going to try to show I'm not the one who robbed the bank because my accent is different. But not being sworn as a witness, not doing it under oath, not being subject to cross-examination means it's probably unfair, and they shouldn't allow it. This was a very short call. It was a very quick call. You only know, the reason why we know that too is it only had one sentence that went to the entire call. So when you only see one fact going to something, it's not going to be that important. How do you know what the main issues are? Where are all the facts? The facts are all right here. Some of the facts are here, but most of them are all right here, what's going on. That's how you know that's the most important issue. Follow the facts. The examiners are trying to tell you something with the words that they use. Okay, well, that pretty much wraps it up for this essay. That was 2004, February question 1, dealt with criminal procedure in 4th, 5th, and 6th Amendment. Thanks for listening.